Good evening, Uganda, and welcome to this edition of On the Spot. My name is Patrick Kamara. We are coming to you from the chambers of the Chief Justice here in Kampala, the Right Honorable Bart Katureebe. It's been more than 8 months since he was appointed Chief Justice, and of course he has traveled all over Uganda. Tonight we want to engage him so that you can hear at home and wherever you are what he's been up to, what the plans they have for the judiciary in our country. Right Honorable Chief Justice Bart Katureebe, thank you for making time to speak to us. Welcome to the show. You're on the spot tonight.
Thank you. You're welcome to my office.
We've seen you move around the country, my lord, and try to visit the courts and visit the magistrates. If you can tell us, what have you found so far?
Well, first of all, when I was appointed, it was necessary for me to familiarize myself with my work, what I have to do. If you're in charge of the judiciary, administration of the judiciary throughout Uganda, then you must know what's going on in the outlying areas, especially up-country areas, because 80% or more of the people who use our services are out there in the countryside. So I thought I was going to get to know what are the conditions out there in the circuits, in the courts. What do people think of us? Because one of my biggest challenges, I think, not my own challenge, but the judiciary, is to create public awareness for people to once again build trust in the judicial system and get to know what we do and what we don't do and to understand us. And I think that visiting these areas and talking to the judicial officers and talking to the civic leaders and talking to the political leaders and talking to the public, I allow the public to ask me questions, is, I think, creating that awareness.
You talk about trying to build relation once again. Those are the words you're using. So does that indicate there has been a time, and in the affirmative, that the relationship was bad between the people and the judiciary?
You see, if you read reports coming out from either the IGG, Transparency International, and other reports in the newspapers, that the judiciary comes out as one of the most corrupt institutions. Now, if that is the depiction of the judiciary, then obviously the public won't have much trust in that institution. So it's important for us to establish the facts and recreate, that's why I'm talking of recreating that public trust, for the people to understand what we are doing, and whether indeed that is a correct depiction of the judiciary.
Is it a correct depiction, my lord?
I don't think so. I think from what I have seen so far, there are many reasons why people will attribute corruption. One, even when you read those reports, they will always say there is perceived and corruption and actual corruption. Now, the perception is what we are talking about. The actual corruption cases can be identified and people can be prosecuted or dealt with. And I think you know that the Judicial Service Commission has, of late, been dealing with such cases, and some people have been dismissed or other action has been taken against them. So that's one aspect. But the perception comes out of a number of what I have seen. Someone loses a case, and the first line of defense for losing his case is the judge must have been corrupted. He does not want to look at the weakness of his case or the weakness of his lawyers or the weakness of his evidence. First thing, the judges must have been corrupted. And I've seen such instances where even there was no such a thing. Two, in my going out and the interactions and questions, sometimes ignorance of procedure. Someone says, I won a case in the Chief Magistrate's Court, then how come I got another judgment against me? Because there were appeal procedures and either he was not properly advised, they didn't understand what to do and so on. A judgment or an order is given because he was not in the proceedings. So there are all these factors. And then we have also got people, found people who will go out. We have staff, clerks and so on, who will go and say, give me this money so that I file your case or I move your case from this judge to another judge, or I will fix it for hearing, or I'll get you a favorable judgment, even when the judge or the magistrate knows nothing about it. So all those create a perception, which it's important to go out and explain and of course fight it.
Isn't it more than just a perception, given the fact that you are trying to strengthen what you have called the Inspectorate of Courts, because that shows the system is weak, it is wanting, and you have identified it. That's why you are strengthening the Inspectorate.
Of course, if you look at all the systems of government, there are weaknesses. And all the time, throughout the world, we are trying to strengthen and close the gaps and the weaknesses and so on. So yes, the Inspectorate of Court was created because we do recognize that weaknesses do occur. Weaknesses in administration, weaknesses in the structure, weaknesses in the provision of...
So, my Lord, this is not a perception issue, no. This is a reality issue.
It's a reality issue, yes. It's a reality issue, but the perception was when someone says the most corrupt institution is this, and then the report goes further and says, but this is perception. That's what people fear. I think you have to make the distinction. Where a magistrate fails in his duty, and this is where the inspection comes in, to make sure that people do their job. For example, simple thing, people come on time. We have many people complaining that some judges, some magistrates, don't report on time. Now, the inspector is supposed to handle something like that. Now, this is not a question of corruption or perception of being corrupt, but being inefficient, being incompetent. This is what we can handle. If there are matters of judicial decisions which have been made by a magistrate, then that's not a matter for inspection. It's a matter for judicial review or judicial appeal.
It's been 8 months since you were appointed Chief Justice. What have been your achievements so far?
Well, I think achievements are always judged against challenges. What were the challenges facing me, so that I can be able to say I have achieved this or that. My first challenge was the degree of public support that accompanied my appointment. I think generally, from the press, from the various people that spoke out, people welcomed my appointment. And that in itself became a challenge, how to live up to that public expectation. Now, that's challenge number one. So the first thing to do was to identify what I have to do to satisfy the public that I know what I'm doing before I even start doing anything, that I know what I'm doing. Find out what are the problems of the institution and so on. And you remember the first thing I said, I've been in the judiciary a while. I've been a judge in the High Court, in the Supreme Court for the last 10 years, but at one time I had been Minister of Justice. So some of the issues were not new to me. I identified as a first thing that sometimes the courts appear inefficient because they are not given enough resources to do their work. In the budgeting process, the judiciary comes off worse. The judiciary is not given the resources, financial resources, they're required to do all the work. And I promised in my early interviews that I would liaise with the other branches of government, the executive, the parliament, to ensure that the judiciary budget gets something more to enable them to do the work that we are supposed to do. And in the last 8 months, I have been able to meet members of the executive. Minister of Finance has been here several times, the president. I've been able to meet a parliamentary committee, which many people at first thought, Chief Justice doesn't do that. But I have met the parliamentary committee here. We had very useful discussions, and they agreed to support our work. And as a result of these interactions, for example, only recently, the Minister of Finance has released to us a supplementary of some 5 billion shillings, some of which we are going to use for case backlog, and some of which we are going to use for enhancing the housing and allowances and medical allowances for judges and other judicial staff. Now, this is something that had been pending for a long time when you consider that the last time judges' allowances were fixed was 1997, and they have remained at the level of 1997, even when housing rates in this country have gone up there. it was as if the government didn't care where their judges live. So that has been one thing. And we set up a committee between the Ministry of Finance, the Treasury, and the Secretary of the Treasury here, the Secretary of the Judiciary here, which is working on the next budget. So that together now we can see what more areas within the national resource can get some extra funding. Now, if that happens, then I think that will be, for me, a major achievement.
It is major in the sense that since 1997, their wages were not raised.
Not wages, housing allowance.
Allowances were not raised,
yes.
And there comes his lordship. You raise it. You must be a popular person in the judiciary.
No, it's not a question of popularity.
You have touched on the emoluments. It's a good thing.
but it's something that should have been done. I mean, you do your job. I was in cabinet when those emoluments were fixed. I was in cabinet as a Minister of Justice. And I remember at that time the Minister of Public Service justification was that the allowances that were being fixed for housing were equivalent to about $2,000, so that on $2,000 at that time a judge could find reasonable accommodation. Now, if you remain with that 2 million shillings equivalent now, and you are 2016, 2 million shillings is probably about $600. So clearly, I'm not asking for anything, a favor. I'm just pointing out the reality that if the principal was to find a judge suitable accommodation befitting of his status, then it has been eroded. Just raise that up a little bit. And so I don't think it is a question of popularity. It's a question of getting people to
2 years. For 2 years, my lord, this country did not have a substantive Chief Justice.
Yes.
And the people below you now were doing the job, and it appears everything was in autopilot and was buoyant. Really, because we never saw any hiccup. And one wonders, is your job so demanding that after all, 2 years, there was nobody like a Chief Justice?
Well, obviously, you didn't take the trouble to find out, first of all, why would the Constitution provide for the Chief Justice if there was no need for it. The Chief Justice is the head of a third branch of government, not just a department, not a ministry of government. It's a branch of government, and is the chief administrator. So if there is an absence, there was where an acting may reach decisions he can make, but everybody holds out and say, let's wait for the appointment of a substantive. And that can have serious, and I'm sure had serious implications. Secondly, the Chief Justice is also the presiding officer over the Supreme Court hearings. It does provide in the Constitution that in the absence of the Chief Justice, the most senior judge will preside over, the most senior judge on that panel will preside. But it is envisaged normally that absence is when he's out on leave or out of the country. It was never envisaged that you would have a country without a Chief Justice for 2 years. Now, it meant that the most senior judge on any panel, whenever the Supreme Court was sitting, in many cases it was me, would preside. Because the acting Chief Justice, the Deputy Chief Justice, does not sit in the Supreme Court. So that aspect of the acting was missed out. And I think people missed out on the implications of that by itself.
So does that also imply that you have found a lot of work on your desk because of that 2-year gap?
Of course. There were a lot of things to be done. I think there were a lot of matters that could have been attended to, but even the acting would say, no, I don't have the full authority to attend to that. And the way people relate to you, you are not in, they are expecting someone in full charge any time now. So it created a situation that I don't think should have happened.
The time prior to your appointment, there was a lot of talk, a lot of pressure from the media, from Parliament, from the civil society, from other concerned stakeholders, because they wanted a Chief Justice appointed. And in fact, your name had been floated many times. Everybody thought you would be the natural or the automatic somebody to take over that position. Yet it took 2 years for that to happen. When when you sit with the appointing authorities, with the other arms of government, parliament and the executive, does that bring you some kind of clash?
No, because there was nothing automatic about my being appointed. It is true the name had come up for consideration and so on, but it didn't bother me because I didn't ask for it. And if my name came up because some people thought I could do it was up to the appointing authority and the process that was involved. If I didn't get it, I was happy to continue doing my job as a Supreme Court judge. So it didn't bother me and didn't create any animosity in me. When it came, I accepted it and I'm doing it. I don't look back and say, why wasn't I appointed and so on. There was nothing automatic about me being appointed. It was not like that at all.
My Lord, I say that because your name was suggested, and every time we would be in this discussion with the civil society and members of parliament, your name would come up. But yet it took 2 years for people, whoever had the responsibility, and I suppose it is the president, to appoint you to do it.
Well, but then you should address your question to them, not to me. Whatever the process took, however long it took, as I said, for me, I was content to sit and do my work at the Supreme Court. And since I was the most senior judge at the Supreme Court, whenever I was involved in any panel, I ended up chairing sessions of the Supreme Court for 2 years. So I was doing my work. And if the appointment came, fine. If it didn't come, I would have continued doing my work. So it didn't bother me. And it's not something I hold now that I've got the job. Instead of doing the job, then to go back and say, why wasn't I appointed within this time and this time? No, it doesn't.
My Lord, we're going to take a break. When we come back, I'll be asking, where is the home for the Court of Appeal, the Supreme Court, and where is the judiciary without the donors like Danida? Because I know they've been involved in building court structures across the country, over 50 of them. So what happens if the donors pull out the money? Where's the judiciary in Uganda? We'll be right back. Welcome back. You're watching On the Spot. My name is Patrick Kamara. My guest tonight is the Chief Justice of Uganda, the Honorable Bart Katureebe. We know the donor community, and especially Danida, they're putting a lot of money in the judiciary, in the building the real structures, which is supposed to be really a job of the state, and they've continued to do that. I wonder always, where would be the judiciary without the donors?
Well, I wish that question was addressed to the larger government, both the executive and the parliament, who allocate the resources. It is true most states would insist the 3 branches of government being properly accommodated. I think the British left parliament, they left this building, and someone could say that is the judiciary, the face of the judiciary, this High Court building. Actually, this was the Chief Justice's office, and court number 1 next was the Chief Justice's court. But in time, because of lack of funds to expand this building and construct proper courts, we ended up the Supreme Court migrating to Mengo first, then eventually being driven from Mengo to Koloro in a rented private property, which was really not meant as a courtroom. It's caused lots of problems. And I think as a country, we should come up with a determination that certain branches of government, institutions of government, larger government, like the judiciary, ought to have a home where you can say that is the face. I mean, you go to Kenya, you see the Supreme Court, you go to Tanzania, you go any country, that is the court. Now, when you go to the court in Koloro, you can hardly call that a court. You go to where the Court of Appeal sits, Twin Towers, they even share the building with other things. Here there's a restaurant there are all sorts of things. That shouldn't happen. However, we operate in a a constricted resource envelope, as the Treasury likes to tell us. So often the country doesn't have all the resources you would wish to do, to do what you want to do. That's when donors and other development partners come in. And definitely the NIDA and the Danish government have done a tremendous job in constructing courts for us, especially magistrates' courts and high court upcountry. And their view is building the headquarters and the Supreme Court and the Court of Appeal really should be a matter for the
Is that
state.
Something that you are super focused at as well?
We are super focused on it. Actually what we have done in agreement with the Ministry of Finance is to move on a private-public partnership to construct the courts. And this has been going on. The process is ongoing. They have identified a partner, someone who is going to do this on a public-private partnership. And I think they have been weighing the bids. They have been evaluating the bids. So the process is ongoing. We hope soon that process should be through and we get to see the fruits.
My Lord, with all respect, you have at one time been there as a minister. And you've been there as a High Court judge. And
Supreme Court judge.
Supreme Court judge. Sorry about that. For the Supreme Court judge. And yet, here, where we are, the chambers, they were built in 1920. Yes. And sometimes I get a feeling that maybe the people in that third arm of government did not do enough to exact pressure on the executive and the parliament to do what is required for the judiciary.
No, I think those who are here did their best. I did one time my best when I was Minister of Justice because the Minister of Justice is the spokesman for the judiciary in cabinet and in parliament. Yes. I think they have done their best, but I think the resource envelope has not always been favorable. This building, as you say, was constructed in the 1920s or 30s, I think 1935. And it's now leaking. The other day I couldn't work because I came in here and everything on my desk there was wet because it had rained and the roof had caved in. So, yes, we are pushing. When the money comes, we do it. And now the solution that has come from Treasury is let's try a private partnership arrangement, and we are trying it. So it's not that people are forgetting about the need to do this, but I think sometimes my own view is they have been somewhat lukewarm.
Look at what they have just added you in supplementary budget, a paltry 5 billion. What can 5 billion do apart from just maybe paying for the allowances and things like that? And yet there are other bigger issues, I suppose. Even these ones are good, but there are other bigger issues.
Well, as I said, this was a supplementary, which has been long in coming. This should have been addressed years ago. But what it will do for me is, initially, if I get the 1.2 billion we have put aside to do some case backlog, I have been moving up country, as you know, and you find people who have been on remand in Jinja, in Tororo, in Soroti, in Mbale. Recently, I was in Arua. Almost all around, people have been on remand, people who have been committed for trial, and the trials are not taking off because the courts don't have enough money to sustain court sessions. I went to Tororo, and the last time a judge was there for a court session was last year. And there has not been another one. Why? Because there were no funds to sustain court sessions. So for me now, even when I get the 1.2 billion shillings, it's something I latch on. And we are going to organize, we are going to send judges out there, and some court sessions will be held. Then we go back to the Treasury and to government and say, look, with 1.2 billion, we're able to do this. If we had 4, we would have been able to do this. What I have been trying to emphasize to both government and to the public is for people to recognize that administration of justice is central to good governance. And good governance is central to development in the country. Because if you have people who remain in jail untried, yet the Constitution provides for speedy trials. And the reason they are not tried is because either you don't have the judges or because you don't have the money to carry out the court sessions. And sometimes we are told the reason you can't have more judges appointed is because there is no money to pay them. Now, whom does it hurt? It does not hurt us only in the judiciary. It hurts the country, the image of the country. Each time I go out there and you visit the prison, I addressed prisoners in Arua on last Tuesday, and they presented to me their memorandum, and you look at it, they have a point. Someone he was committed for trial 3 years ago, and he has not had a trial. Someone's case was proceeding when the court last had a session. It got halfway. The judge said he has run out of money. The court session was suspended, and it has not resumed a year later. Now, those may be inefficiencies within the judiciary which can be addressed. But if it is a question of a financial resource envelope, then we ask the other branches of government to see that actually that's a failure on us as a state. When we fail in administration of justice, we are failing in good governance. And when you fail in good governance, it affects all other things. Even the people who want to come and invest here, when they look at these statistics, if I get a case in Uganda, it may be 5 years before I get a trial. If I have a civil case, it may be several years before it is finalized. It affects the public confidence of even people who would like to come here. So this is a point I've been trying to make out to the other colleagues in the other branches of government.
There's one thing I've noticed. Cases on land, the land issues, they really take long.
Yes.
They drag on about maybe 4 or 5 years. I wonder why.
I think land is a very complex matter because I think we still have to resolve matters of the law affecting land. The tenure system and the procedures. If you remember when we enacted the Land Act, we provided for land tribunals. Every district have a land tribunal to resolve quickly land disputes. Then in time, the government found it difficult to fund land tribunals. They didn't work. They toyed with the idea of combining 2-3 districts and have one a land tribunal. That also proved unworkable. And in the meantime, land disputes were out there and addressed until by a practice direction, the Chief Justice then decided that instead of creating that vacuum, let the magistrates resume as judicial officers. Now, that took a bit of time. Now, the requirement of the law is that magistrates must visit what we call locus nuco. They must visit the site where the dispute is. Then you have magistrates without transport. So you can have a situation where someone has a dispute and he offers a lift to the magistrate to go and resolve. Now that's a matter of perception that we were talking about before. So these are some of the things that have clogged the system in the administration of land disputes. So I think the situation will have to be addressed in a holistic manner. Deal with the law. You have someone who has a mayoral title, so he has a legal title. You have someone who has a chivanja on that mayoral title. He has a certificate of occupancy, so he now also has some paper. And you have clashes of interests and so on.
You recently, just about a week ago, completed the national court census. And what were the findings and how clogged is the system?
Actually, I have not finished it. Okay. We closed courts for 2 days. The reason is this. When I came in, and by the way, this is not only Uganda. I think all courts all over the world have had this thing called case backlog. Now, case backlog means you have cases in the system that have been there for more than 2 years unsolved, unresolved. So when I came in, we were talking of how many cases do we have? And you had various figures being bandied about, 200,000 cases.
Unresolved.
Hundreds of thousands of cases. But if you are going to solve a problem, you better first know the magnitude of what you are going to do. Because it involves finding the resources, the personnel to solve the problem. So you first need to know what exactly you have. And we have made some very interesting preliminary findings. You find in a court where they were reporting 5,000 cases, now you find it is actually 2,000. Why? We need to find out. Was it because someone was not entering data in the system, or was it deliberately the system being fed with wrong information, so that someone creates an impression that this court is so busy, it has so much work and needs more resources? We need to find out. That's what this census is going to capture. So the raw data that we have, I was looking at what they have given me. For example, I will give you the criminal division of the High Court in Kampala. As of when we started the census, what they were reporting was that they had 4,344 cases. Preliminary results show that it's actually 871. So the problem is not as big as one would have thought. So we hope in another case, the family division was reporting they had 5,442. Preliminary report shows they have 2,530, almost half. So in other words, if we are now going to go out, either to the Treasury to ask for more funds to deal with case backlog, or to our development partners, we can now go to them and say, this is the problem.
It appears, my lord, that people are creating some ghost cases. If I use the lingo of today.
I don't want to say ghost. As I said, these are preliminary results. The chart which we are using to capture information is much more detailed. We are going to have some expert analyze this sort of data. We want to know of the cases, for example, how many are actual civil suits or criminal cases, how many are applications. Or you find somebody filed an application, then abandoned it 3 years ago, so it's not active, but somehow it is still in your system. So I don't want to speculate until all this data has been analyzed. So it will give us a base for further action.
So when do you intend to follow them to their logical conclusion?
We hope this exercise to be ready by February. By the end of January, early February, I should have a complete result, and then we'll start planning. So do we recruit more judges?
Does that imply, my lord, that for those who have been having court cases and their justice is delayed, and so in other words, like they say, almost denied?
Well, justice, I earlier on told you, the Constitution provides for speedy trials. So we want to find out what has been going wrong, what went wrong. Some courts, for example, if you take the Court of Appeal, there was a time they spent a year or two without the necessary number of judges. And that's a court which operates on a quorum, not to single judges. You must have a minimum of 3 for the session to take place. If you take the Supreme Court where I sit, there was a time when we were still in Mengo, and we also went for almost 2 years without being able to sit because we didn't have a quorum. Even today, as I speak, we have had 5 judges appointed to come, but these judges have been completing their cases which they hadn't finished at the Court of Appeal. And consequently, because that left us only 4, we have not been able to have a session this quarter because we couldn't raise a quorum. We need a minimum of 5 to hear any case. So consequently, the work which should have been done this November, December has not been done. So there are other factors that have affected the courts in terms of the High Court. The High Court now should be having 50 judges, although there have been proposals to raise it to 82. And now some judges have retired. Some judges have been promoted to the Court of Appeal. And the component at the High Court is now less than 45 judges. So even if you said these cases that we are going to deal with, let's say you have 1,000 cases, and you said each judge go and do this case backlog, and you give this judge a case per day. Now, to do 1,000 cases, one judge would require 1,000 days.
You're going to take a break, my lord, you're going to take a break. When you come back, I'll be asking on the issues of the Constitution itself, because it's the supreme law of the land. It demands and commands that it should be translated in the local languages. Up to now, we don't see the Constitution in the local languages of about 50-something languages in Uganda. Whose job is it to translate this so that Ugandans can know the supreme law? We'll be right back. Welcome back. You're watching On the Spot. My name is Patrick Kamara. My guest tonight is the Chief Justice of Uganda, Right Honorable Bart Katureebe. The Supreme Law, my lord, of Uganda, the Constitution of Uganda, also demands that the Constitution is translated in the local languages, that people of Uganda who speak different languages can understand it. But up to today, since 1995 when it was promulgated, it is still mainly in English. How can the people follow the law if they do not understand it?
Yes, that's a concern. It was a concern to us when we were making the Constitution. And that's why we provided, for example, that one of the functions of the Judicial Service Commission would be to educate the public and publish materials and educating the people about the law, the Constitution, and so on. And I think there have been a number of translations in some languages. I can't tell you which one, but I think there have been some.
I haven't seen mine, which is which is rhetorical.
You may cross-check with the Judicial Service Commission. I think they have done something on that. I don't know whether the Ministry of Justice has also done something, but it's not one of the functions that the judiciary does. But it would be very useful indeed if people really understood.
Does it bother you that maybe in some cases the people of Uganda, majority of them do not understand the Supreme Law, the Constitution, the laws of Uganda, as it were, and yet they have to be judged upon them? I know ignorance of the law is no defense, but does it bother you that they do not know?
It really doesn't bother me as such, because it's not everyone who can understand the law. But it's enough that the people who are responsible for educating us do actually go out and carry out this outreach in schools, in the public, have these pamphlets out explaining the Constitution, even if it is not the paragraph by paragraph replication of the Constitution, but explanatory notes about what this provision does. I think that's what they have tried to do, and they should do it. It helps people to understand what their rights are, especially when it comes to rights. That's why the idea why it was required in the Constitution, as you say, to translate the Constitution and make people understand it, so that especially they can fight for their rights. So I agree with you, and I think the relevant departments are doing what they are supposed to do. I know the Judicial Service Commission has put out something. My
lord, in your travel around the country, did you see the issue of complaints against judges? Because it happened something back, there were so many complaints over corruption. And what is your remedy?
You see, I have received some complaints. Fair hearing, natural justice demands that when you receive a complaint against an officer, it has to be investigated. You can't take it at face value. Otherwise, right now myself, there are some people who have been extorting money from people, claiming that the Chief Justice had asked them to bring money for him.
Even you?
Even me. And these are lawyers. So when these allegations come, it's absolutely necessary that they are investigated. And so I received some complaints, for example, from some lawyers. I subjected them to an investigation. We have an internal disciplinary committee here in the judiciary. So when we get this complaint, it goes to that committee. They look at it. The officer is asked to respond to the complaint. His responses are weighed against the complaint and any further evidence that can be brought.
So the conduct of lawyers in the eyes of their clients, in some cases, is appalling.
Well, yeah, the conduct of some lawyers leaves a lot to be desired. If you went to the disciplinary committee of the Law Council, you would be amazed by the number of complaints against advocates that are being handled by the disciplinary committee of the council from clients. So sometimes that causes us problems, because a lawyer may go and demand money from a client, and he says, you see, we have this matter before the Chief Justice, and the Chief Justice wants so much money. The Chief Justice knows nothing about it, like in the case I'm telling you, because this is a matter apparently which is somewhere in the High Court, but someone goes and deceives clients that, you see, this matter now has even reached the Chief Justice. And these are foreigners who don't know our systems. The matter has reached the Chief Justice, and the Chief Justice wants so much money. Otherwise, he has written a letter which will lead to your deportation. And these fellows talk about it.
So what action are you going to take for
we
such
are
people that have
we
maligned
shall
your name?
investigate. No, we shall investigate. But I'm giving you this as an example of where there is need to investigate each complaint that comes. So those that came, we subjected them to that committee. And the committee has come up with its recommendations. We have actually sent some of those back to the people who raised the complaints and said, on this one, this is what is being proposed, and do you have any more evidence, any more suggestion? Now, when the committee has finally dealt with the matter, the body which has disciplinary powers over judges or judicial officers is the Judicial Service Commission. So we then subject this to the Judicial Service Commission. If it is something that we can handle here, sometimes something you can call a judicial officer and admonish them. If it is not something going into bribery and so on.
Which makes me think, if there are people in the system who can even refer to your name, yet you are a man with impeccable credentials.
Oh, yes.
A man of integrity that everybody knows. But
yes.
if they can malign to your name to that extent,
then they can malign anybody.
Doesn't that indicate that if this was a body, it's really suffering from almost multiple organ failure about to collapse?
No.
Because if your name can also be maligned.
No, it just shows we have a problem in the country. It just shows there is a problem in the country where people think anything to get you money goes, irrespective of whom you are hurting. I think you have heard of stories of people trying to extort money from people in the names of State House, even the forging. I think at one time there was a case where somebody is supposed to have forged the signature of the president. So such a people are there. All I'm saying is that when I get a complaint about any judicial officer, and it could be me, it should be investigated. And then action is taken. The person who complained is told, yes, we investigated your complaint. This is what we found. If it is still lacking in evidence, the man will say, I have more evidence. Here it is. I have been going up country, and I have found such complaints. And in one complaint, someone said, these clerks in this court are very corrupt. They take people's money. So I said, fine. I always go with the team from the Inspectorate of Government of Courts. We take down, then my team goes back, that person is called back, start giving us more details and so on. Now, in that particular case, when we went back, this gentleman said, you see, I have been asking for a hearing date for my case, and these people have been avoiding me, so I assumed they wanted me to give them money. Now, this is an assumption, not that really anybody had asked him for money. On the other hand, in another place, someone says, I came here, and someone asked me for money, 2 million shillings, and I paid it. I even have a video recording of it. So that one, we get hold of the video recording, and we subject it to investigation, which is going on now. So we have found that some are genuine complaints, some are a misunderstanding. Sometimes people don't understand the orders that have been made against them. Another case that came up was decided by the highest court, and somebody quickly wrote and said that these people have been paid so much money by so and so. And I felt so concerned. I even called in the IG to investigate some aspects of it. Then I invited this complainant here. I sat with him here. And it turned out, I was very angry and so on and so forth. And subsequently, his lawyers have written an apology. So,
my Lord, I want to draw your attention to the times we are in. We are in an election period.
Yes.
And of course, we saw people in Ntungamo recently getting beaten and are emotionally charged. I wonder what you, as the other arm of government, you could do, because what happened in Ntungamo was diabolical. And is there anything you could do to rein in?
Well, there are other branches of government who are charged with that responsibility. All I would say is that whether it's election time or not, the leaders, first of the political parties, the civic leaders, the political leaders, must emphasize to all of us that the law must be enforced, must be obeyed, must be applicable at all times, even when it is political times, as you put it. If people should hold their rallies, people should be allowed to say what they want to say. People should be able to be prevented from interfering with others in accordance with the law. And the Electoral Commission has got that responsibility. The police have that responsibility. They should all come up and then the leaders, as I said, the leaders of the parties and so on, rein in their supporters. Let's have a peaceful election and people decide.
I'm imagining you could have watched the images coming from Ntungamo. I don't know what you make of them.
Well, I saw bits of the video. If that's what happened, then of course it should be something that should be deployed by everyone. It shouldn't happen. Anytime you see anyone beating another one outside the law, that's extrajudicial. It shouldn't happen. If you have a complaint against a person, take it to the court. Take it to the Electoral Commission. There are channels, even now under the Parliamentary Elections Act or the Presidential Elections Act, where matters of complaint can be channeled either to the Electoral Commission or even to the courts, if you have to. But this taking the law into your own hands is something that I think we should not encourage.
My Lord, there was a time when these very chambers and the courts around, well, people sometimes refer to it, they were defiled, or there was a rape of the temple of justice when the case of the Black Mambas. Do you really think that is a bygone?
That should be a bygone. I believe it's a bygone, and I remember at that time the judges did something rare when they put down their tools, not to claim for any advantage to themselves, but as the principle said, this must not happen. And the judges met the president who gave them assurances that that would not happen again, and it hasn't happened. I think people must be educated. The police and all law enforcement agencies must be educated that this country can only survive in peace if we respect the law.
Thank you. Your concluding remark on the show tonight?
Well, I just implore people to give us all the support as a judiciary. Give us the support, give us the understanding, report to us problems, and also demand that the judiciary be supported. When I was in Arua, the leaders there, I was happy to hear the leaders say, next time it's us who are going to be telling the government that more money should be given to the judiciary so that they reduce on the case backlog, especially of the people who are in prison awaiting trials and the trials are not taking place. Then for us, we undertake, we shall do our best, we shall give us the tools. I think there is, I detect that there is a feeling of hope within the judiciary and outside the judiciary that things will probably change for the better. And I have established very good working relationship with the other branches of government, and if it continues, I think we should be able to achieve something.
My Lord, thank you very much for your time.
Thank you very much.
Thank you. You have heard him there, His Lordship, the Chief Justice of Uganda, Bart Katureebe. He speaks with a lot of clarity, so I'm sure you have understood him. And that brings us to the end of tonight's edition of On the Spot. Join us again next week when we bring you yet another edition with a person of high name recognition and those who take decisions for your country. Good night, and God bless Uganda.